Hello everyone, welcome back to Leagles Educare. In today's video, we are going to talk about Nikah, the Islamic marriage, Halala and Muta marriage. These may sound a bit tricky, but I am here to explain them in the simplest way. By the end, you will know what they mean and how they work in Islamic law. Let's get started. Let's start with Nikah, which is the basic form of marriage in Islam. Nikah is an Arabic word which means the union of sexes. The Prophet is reported to have said, Nikah is a part of my sunnah, and whoever does not follow my sunnah has nothing to do with me. Nikah is not just a religious ceremony, but it is also a legal agreement between two parties. In a nikah, both the husband and wife agree to live together and support each other. The marriage contract is witnessed by two people, and one of the key parts of this contract is something called the meher. The meher is a gift that the groom gives to the bride. It can be money, jewelry, property or anything they agree on. Maulvi and one witness from each sides will read out the nikah nama to the bride. It should be heard by the bride. Husband's name and his father's name shall be told to the bride, and the meher shall be read out 3 times to the bride. Nikah nama shall be read out to the bridegroom as well. Meher will be read out to him as well. Bride's name and her father's name will also be read out to him. Bridegroom has to say 3 times, Kubul hai, Kubul hai, Kubul hai. This is not just a formality. It's important because it shows the groom's responsibility towards the bride. For example, Ahmed is marrying Fatima. Ahmed offers 1 lakh rupees as meher, and this amount is announced 3 times during the ceremony to make sure Fatima fully understands and agreed to it. Why 3 times? So there is no confusion and everyone knows the bride is giving her full consent. Nikah is more than a religious practice. It is a legal contract with specific terms and conditions. Just like any other contract, certain rules must be fulfilled for it to be valid. For a nikah to be valid, both the parties must meet essential conditions: the capacity to marry, free consent, and the absence of any legal prohibitions. Both the bride and the groom must agree to the marriage. If either one is forced, the marriage is not valid. That's because nikah is seen as a contract, and like any other contract, both persons have to agree freely. For example, nikah through internet and telephone, parties are not sitting in front of each other. But the nikah is proper if the offer and acceptance is done in the same transaction. The offer and acceptance should be unambiguous and clear. In case of a minor or unsound mind person, guardians can make proposal and acceptance on behalf of such minor or unsound mind person. For example, Ahmed is in one city and Fatima is in another city. They can still get married online as long as they both say yes to in the same meeting and in front of witnesses. As long as the rules are followed, their marriage is legally valid. But why does Islam place so much importance on nikah? Marriage in Islam serves 4 main purposes. First, to restrain sexual passion within a lawful relationship. Second, to maintain order in domestic life. Third, to expand the family. Fourth, to ensure the upbringing of virtuous and moral children. So nikah is not just about 2 persons getting married, it's also about building strong families and communities. For example, when Fatima and Faizi get married, they are not just starting their life together, they are also taking on the responsibility of raising a family in a way that benefits society. Now let's talk about how Muslim marriage differs from Hindu marriage. In Islam, marriage is seen as a legal contract where both the husband and wife have clear rights and duties. One key part of this contract is the meher, which the groom must give to the bride. In Hinduism, marriage is more of a sacred act that binds the couple not just for this life but for 7 lives. They perform religious rituals like Saptapadi, walking around the fire 7 times to seal their union. For example, in a Muslim marriage, the groom like Faizi must give Fatima meher. It could be money or property. In Hindu marriage, there is no legal requirement for this kind of gift, although dowry practices have been common in the past. In Muslim marriage, the bride keeps her own legal identity after marriage. This means she can still own the property, run a business, or even file a divorce if she needs to. She does not lose her rights just because she gets married. For example, after marrying Faizi, Fatima can still own her own property or start her own business. She has the freedom to make decisions about her life just as she did before marriage. Divorce in Muslim law is also more flexible as compared to Hindu law. In Islam, a man can divorce his wife by saying talaq, and a woman can also ask for divorce in certain situations. But here's the important part. The Supreme Court recently ruled that triple talaq, where a man says talaq 3 times times in a row to instantly divorce his wife is not allowed. It is unconstitutional. In Hindu law, divorce was not allowed for a long time, but now both men and women can divorce under certain conditions like cruelty or mutual consent thanks to the Hindu Marriage Act. Now let's talk about the option of puberty, which is also known as khayarul bulugh. This is the right of a minor who was married by his guardian to either accept or reject the marriage once he reaches puberty. Let's break this down step by step. Under Muslim law, there are 3 stages of life that matter when it comes to marriage. Number 1, Sagir. This is when a child is under 7 years old. At this age, marriage is not allowed and any marriage is automatically void. Second is Sariri. This stage is between the ages of 7 and 15. During this time, the guardian can arrange a marriage for the child, which is called Jabr. Third is Bulugh. This is when a person is 15 or older. At this point, they can decide for themselves if they want to get married without needing the guardian's permission. In cases where a guardian arranges a marriage for a minor, only certain people can act as a guardian. These include number 1, the father, second, the paternal grandfather, third, brothers or other male relatives from the father's side, next, maternal uncles or aunts, and the last one is the state in special situations. For Shia law, only the father and paternal grandfather can arrange marriages. Now, let's look at 2 examples to understand how this works. First, boy is 17-year-old and girl is 15. Here, both the boy and the girl have reached puberty, so they do not need their guardian's consent to marry. Now, another example where boy is 17 and girl is 12. In this case, the girl is still a minor. In a famous case, Abdul Ahad versus Shah Begum, a 14-year-old girl's marriage was arranged by someone who was not a proper guardian. The court held that the marriage was invalid because it was not arranged by the right person. The guardian was not proper. If a marriage is arranged by someone who does not have the right to do so, it is called Aqd Fazuli. Once a child reaches puberty, he has a right to accept or reject the marriage that was arranged by his or her guardian. This is called the option of puberty or khayarul bulugh. If they don't want the marriage, they can repudiate it. The marriage is not valid unless the child agrees to it after reaching puberty. Under the old law, if the father or grandfather arranged a marriage, it was considered valid unless they acted wrongly. But thanks to the dissolution of Muslim Marriage Act 1939, minor girls now have more rights. A girl who was married before she turned 15 can reject the marriage before she turns 18 as long as the marriage has not been consummated. Boys also have the right to reject a marriage arranged when they were minors. They can reject it anytime after they turn 15 as long as they have not consummated the marriage. But they need to get a court decree to officially end the marriage. To sum up, khayarul bulugh gives minors the right to decide about marriages arranged by their guardians once they reach puberty. The law has evolved to give young people more control over their lives and marriages. Now let's talk about the concept of legal disability in Muslim law, which essentially means certain situations where marriage is not allowed. These prohibitions are divided into 4 major categories, and I'll break them down for you one by one with easy examples. So let's dive in. Number 1, absolute prohibitions. Absolute prohibitions mean marriages that can never take place under Muslim law. If such a marriage happens, it is void, it has no value in the eyes of law, and the children born out of such marriages are considered illegitimate. Number 1, consanguinity, that is kubarat. Consanguinity refers to blood relationships, and here are some examples where a man cannot marry a woman related to him by blood. Number 1, a man cannot marry his mother, his grandmother or even great-grandmother, no matter how far back. Similarly, he cannot marry his daughter, granddaughter or great-granddaughter. He also cannot marry his sister, niece or any woman related by blood at any level. And key points to remember, marriages within these relationships are void. Children from such marriages are illegitimate, but there is no prohibition on cousin marriages in Muslim law, so cousins can marry freely. Next is affinity, that is mushara. Affinity means relationships created through marriage. Here is where a man cannot marry, number 1, his wife's mother, grandmother or great-grandmother. He cannot marry his wife's daughter or granddaughter, but this only applies if the marriage with the wife was consummated. He cannot marry the wife of his father or grandfather. A man cannot marry his son's wife, grandson's wife or great-grandson's wife. There is an important point. Just like consanguinity, marriages prohibited by affinity are also void. Next is Fosterage, that is Riza. Fosterage happens when a child under the age of 2 is breastfed by a woman other than his biological mother. This woman becomes his foster mother and the child has foster relationships with her family. A man cannot marry his foster mother, his foster sister. But the important point here is fosterage has become less common in modern times, especially in Indian Muslim families. However, under Sunni law, there are a few exceptions, like a man being able to marry his foster sister's mother. Next is polygamy, marrying a fifth wife. Muslim law allows a man to have up to 4 wives at a time. But what happens if he wants a fifth wife? He can only do that by divorcing one of his current wives first. If a man marries a fifth wife without divorcing one of the 4, the marriage is considered irregular. Now let's talk about second prohibition, that is relative prohibitions. Relative prohibitions are less strict than absolute prohibitions. If the reason behind the prohibition is removed, the marriage can become valid. Let's look at a few cases. Number 1, unlawful conjunction. A man cannot marry 2 women who are so closely related to each other that if one of them were male, they could not legally marry. For example, a man cannot marry his wife's sister while his wife is still alive. But if he divorces his wife or she passes away, he can marry her sister. Next is polygamy and irregular marriages. As I mentioned earlier, Muslim law permits having up to 4 wives. However, marrying a fifth wife without divorcing one of the current wives is not allowed until the irregularity is fixed by the divorce. Next is witnesses. In Sunni law, for a marriage to be valid, there must be at least 2 male witnesses or 1 male and 2 female witnesses. But in Shia law, no witnesses are required at the time of Nikah, that is marriage. However, witnesses are required for a divorce in both Sunni and Shia laws. Now let's talk about another prohibition, that is difference of religion. A Muslim man can marry women from different religion, but the woman should be from the Kitabiya religion, meaning the religion must follow the book, like Christians and Jews. But they cannot marry women from religion that are considered idol worshippers like Hindus without converting them first. Next is directory incapacity. There are 4 main situations that can lead to directory incapacity. Number 1, marrying a woman who is already pregnant, that is onshan. It is unlawful for a man to marry a woman who is already pregnant by her former husband. For example, if a woman is already expecting a child, a man cannot marry her until child is born. This ensures that the paternity of the child is clear, preventing any confusion over lineage in Muslim law. Next is prohibition after divorce, that is talaq. In Muslim law, if a man divorces his wife by pronouncing talaq 3 times, the marriage is completely dissolved and reunion becomes prohibited unless specific conditions are met. For the couple to remarry, the woman must first marry another man and consummate that marriage and then lawfully divorce him before she can return to her first husband. Without this process, a remarriage between the divorced couple is considered invalid. Next is marriage during pilgrimage. Marriage during pilgrimage has different rules under Muslim law depending on the school of thought. According to the Shia, that is Shafi school, if a person is in the sacred state of pilgrimage, that is Ihram, entering the Kaaba in pilgrim dress, marrying another woman there is not valid. However, under Sunni law, such a marriage is considered valid even during the pilgrimage. Next is marriage with a sick man. Marriage to a sick man who is suffering from a disease likely to be fatal is generally considered invalid in Muslim law. However, there is a special condition that can change this. If the sick man can recover from his illness and the marriage is consummated, then the marriage becomes valid. This rule ensures that marriages during life-threatening illnesses are handled with care, ensuring the rights of both the parties are respected. So those were the 4 main situations of directory incapacity in Muslim law. Even though these marriages may face some irregularity, they can often be fixed depending on the circumstances. Now let's talk about halala, a concept that people often misunderstand. If a husband divorces his wife, they cannot get married again unless the wife first marries someone else, lives with him as his wife and consummates the marriage and then gets divorced. Why does halala exist? It is there to stop people from getting divorced and remarried too quickly. This rule makes sure that people think seriously before ending their marriage. Suppose Ahmad divorces Fatima. They cannot get back together unless Fatima marries another man, let's call him Ali. Fatima and Ali live together as husband and wife and the marriage consummates. Ali divorces Fatima and she completes her waiting period, that is called iddat. Only then can Fatima marry Ahmad again. This process is meant to make sure that people don't take divorce lightly. Now let's talk about Muta marriage. This is a type of temporary marriage practiced mainly in Shia Islam. In a Muta marriage, the couple agrees to be married for a set period of time. Once that time is up, the marriage ends unless they choose to extend it. For example, Fazal and Fatima agree to a Muta marriage for 6 months and Fazal gives her 1 lakh rupees as meher. After 6 months, the marriage will automatically end unless they both decide to extend it. Rights and rules of Muta marriage. Unlike Nikah, which is a permanent marriage, Muta is a temporary marriage. There is no inheritance between the couple unless it's stated in their contract. But any children born from a Muta marriage are considered legitimate and can inherit properties from both the parents. Now let's talk termination and hibaye muddat. In a Muta marriage, the husband can end the marriage early by gifting the remaining time to the wife. This is called hibaye muddat. For example, Fazal and Fatima agreed on 1 year Muta marriage, but after 6 months, Fazal wants to end it early. He can give her the remaining 6 months as a gift and the marriage will end early. Muta marriage is different from Nikah in a few ways. First, Muta is a temporary marriage while Nikah is meant to be for life. In Nikah, the wife is entitled to full meher whether the marriage is consummated or not. But in Muta marriage, if the marriage is not consummated, the wife only gets half of the agreed meher. For example, if Fazal and Fatima have a Muta marriage but do not consummate it, Fatima will get only half of the meher. In a Nikah, she would get the full amount no matter what. So now you know that Muslim marriage can take different forms, whether it's a permanent commitment of Nikah, the special rules of Halala, or the temporary nature of Muta marriage. Each one has its own purpose and rules that help protect both the couple and the community. Let's conclude this video here only. Thanks for watching. If you learned something new today, don't forget to like, share and subscribe to Leagles Educare. Got any questions or topics you want us to cover? Drop them in the comments below. See you next time.